Hello and welcome back to our series of videos on intellectual property law and how you can improve your legal English if you're working in these fields. Welcome to part 6, where we're going to talk about the various types of trademarks that are available. What kind of products can be trademarked and what can the trademarks consist of? My name is Jeff Keiser. I've been a practicing attorney for 15 years, but I'm also one of the best legal English educators in the country. I've taught hundreds of students around the world how to use the English in their practice and how to make them better lawyers by using legal English, by using it well, by being more confident in their speaking and writing abilities. And it's my pleasure to be here with you today. Like we covered in the last video, a trademark offers legal protection for any word or symbol, phrase, logo, design, or a combination of those that represents the source of goods or services. There are 5 main types of trademarks, and we'll handle them each in their own slide. There's a generic mark, a descriptive mark, a suggestive mark, a fanciful mark, and finally, an arbitrary mark. We can't trademark anything. They have to fall within one of these categories. So we're going to start with a generic trademark. And these don't always qualify for trademark protection. We might have to have a little bit more detail in there. Think about this. A generic phrase, some business is called the ice cream shop. But every ice cream shop is an ice cream shop. So if you trademarked the ice cream shop, all other ice cream stores in the world might be infringing upon that trademark. That hardly seems fair, or frankly, like the kind of world I want to live in. So for a generic mark to become a trademark, it needs to somehow describe the qualities, characteristics, or ingredients of the good that your business sells. So, Band-Aid. This is a trademark that used to be owned by Johnson & Johnson, but has now become generic. Same with the Post-it note, or the hula hoop, or bubble wrap. These used to be trademarked and owned by 3M or another manufacturer. Over time, though, these have become, they say, genericized. They have become generic. And in the United States, for example, here's one. We use the word Xerox as a verb to photocopy something. Xerox is a company that cannot trademark their very own name because it has become a generic mark. A descriptive trademark, on the other hand, will identify one or more characteristics of the product or service. It has unique elements that qualify it for protection because it has a secondary meaning. These are the marks where we instantly recognize the trademark and identify it with the brand. Bank of America is one of these. It says that it's the Bank of America. American Airlines, the same situation. Now, we're not talking about all airlines in America or all banks in America. These are descriptive trademarks that say a little bit more about the company. Moral rights is a very interesting concept in the law, and this is one part of intellectual property law that changes around the world. This gives the author the right to protect their work One example of this is if someone were to buy the Mona Lisa, the painting in the Louvre, and want to paint a big X on it for some political statement, moral rights would allow the author to step in and prevent them to change the work. These are unheard of in American law. They simply don't exist. But in Europe and other parts of the world, they're a very important part of intellectual property law. A suggestive trademark. These imply something about the good or the service. Here we don't have to have a secondary meaning like we did with descriptive trademarks. By saying suggestive, we're saying that the customer needs to figure out what the goods or the services the companies offer. So think about the car brand Jaguar. Obviously, there's not going to be a big game cat in the car. But it does suggest that it's fast and quick. It doesn't automatically make you think of a car, except for this one, because it's developed this suggestive meaning over time. Here are a few others. Airbus. It's exactly what it sounds like. It's a bus in the air. These all have been declared to be suggestive trademarks and absolutely have protection. A fanciful trademark is a term, name, or logo that is different from anything else that exists. It's a made-up category in a way. It doesn't become generic easily, and it doesn't really compete with other words. Names like Kodak or Nike or Adidas, they don't really mean anything, at least to my knowledge. So trademarking them won't infringe on the rights of other companies that offer similar products. Finally, an arbitrary trademark. This is a term or a phrase that might have a well-known meaning, but as a trademark, it means something different. The best example here is Apple. They make computers. They don't sell apples. Everyone knows what an apple is, right? But the trademark has nothing to do with the general meaning of the term. And I will touch on these very quickly. That's a service trademark. This is a service that operates the same way as a trademark, but it's not a product, it's a service. It still needs to be registered with the USPTO, and it still offers the same kind of protection. But one great example would be McDonald's. They don't sell a McDonald's. They provide a service in a way. It represents the services provided by that restaurant. All right, that wraps up our video this time. We'll be back with more fun-filled discussion of trademark in our next video. I will see you then. In the meantime, have a great day.